Hello, my name is Benjamin Sanchez. Welcome to another edition of Legal Grounds Live. Have you ever wondered what happens when you can't afford to file a lawsuit or you can't afford to file an appeal? Well, Texas has a solution for that, and that's called a statement of inability to afford payment of court costs or an appeal bond. Yesterday, I discussed that overall, and I will bring that up for you so you will be reminded. So this is the form that I discussed yesterday. As you can see, it's the statement of inability to afford payment of court costs on appeal bond. If you go down, you'll see that all sorts of information has to be provided. It has to be either done under oath or through a signature under this penalty of perjury. Either way, it has to be done with truthfulness, and if not, sanctions can potentially arise if someone files this and lies on the form. That is different than sort of maybe forgetting or not intending to lie. But if it's found out that someone has lied to the court through this form, they could be subject to sanctions. Today, I want to discuss the topic of contesting this statement of inability to afford payment. So let's go over here. So you will see that there's all sorts of information that needs to be included on this statement of inability, including public benefits, whether or not you're represented by legal aid, dependents, where you live, what your income and wages are, what your sources of income are, the property value, if you have any. It could be bank accounts, cars, other personal property, real property, such as real estate, also your monthly expenses, and then any other debts or facts explaining the financial situation. And then at the bottom, you need to check whether or not you cannot afford to pay court costs or the appeal bond. Now, with that said, it's important to understand that in Texas, although you are allowed to file this, it doesn't mean that you automatically don't have to pay court costs forever. There is a process within the Texas Rules of Civil Procedure that allows different parties, different entities to potentially contest this statement. This statement can be contested by the opposing party. It can be contested by the court clerk, because the court clerk is the one that normally receives the payment of the fees. So the court clerk has standing to contest it. An attorney ad litem who's appointed in a family case to represent a parent can contest this, because normally those fees will be paid by the other parent. So in that case, the inability to pay does allow the ad litem to be appointed on the public rolls. So the ad litem can do that. The court reporter can potentially file such a contest, and then the judge, him or herself, can do that as well. Now, there are two different rules I want to briefly go over in the Texas Rules of Civil Procedure. You can write this down or watch this replay, but the first rule is Rule 145. Okay, and I want to show that to you real quick. Okay, we're talking about Rule 145 of the Texas Rules of Civil Procedure. Now, the purpose of these videos is not to go into a lot of detail in terms of legalese language. So I really don't want to get into the nitty gritty of everything here, but I do want to show this to you. So let me do this. I'm going to show you this here. Oops, sorry about that. You can tell this is live, ladies and gentlemen. Let me just get this to you real quick here. All right. So you can find the Texas Rules of Civil Procedure online. If you just Google Texas Rules of Civil Procedure, you can go to the Texas Supreme Court website, and the website, under a tab called Rules and Standards, has the most current rules out there. Now, these rules are updated fairly often, sometimes annually, sometimes every 2 years. So you don't want to look for just any version of the rules, because the rules have gone under some changes, especially even as of January 1st. What I'm showing you here is Rule 145, payment of costs not required. So generally, when you file a statement with the lawsuit, the clerk has to take it. If someone decides to contest this statement, then you're allowed to have a hearing on it. The Texas Rules of Civil Procedure allow you to have a hearing on it in which evidence will be presented. You have to have a certain notice of that. And let me show you what that is. If you will look at number 5 here, you will see that you're allowed to have a 10 days notice of the hearing. Now, once you have the hearing, there must be findings, detailed findings by the judge as to your financial condition. In other words, the judge can't just make an order that says the contest is granted or the contest is denied. The judge has to put into an order detailed findings about your financial condition as part of the order. That's required by the Texas Rules of Civil Procedure. The thing is that the judge, in addition to granting or denying, the judge can partially grant. In other words, the judge can decide that you need to pay part of those fees, or the judge can decide that those payments of court costs can be done in installments, right? That would be under E here, under 7, partial and delayed payment. Now, the you as the person filing this statement, you're the only one that can appeal it, which means that if the judge denies the contest, neither the clerk nor the court reporter, nor the judge, him or herself, nor the attorney ad litem can appeal an order denying the contest. However, if the judge sustains the contest, you, as the declarant, as the person filling out that form, you have the right to file that with the Court of Appeals. Now, there's a limited time for you to do that. I don't want to get into the nitty gritty of that, but if you lose the contest, you do have the right to appeal, but you need to act upon that right away. Now, the second situation a lot of this comes up in is an appeal bond. And in my practice in everyday consumer law, this comes up a lot in appeals from JP courts to county courts. Because in Texas, we have a right to trial de novo when something is appealed from a JP court to a county court. However, the JP court usually sets an appeal bond, and it can be different in all situations. Normally, it's going to be 2 times the amount of the judgment. So if there's a judgment for $5,000, the appeal bond would be $10,000. If you can't afford the actual $10,000, or you can't afford to get a bond, which is normally 10% fee at a bonding company, if you can't afford even the $1,000 on that $10,000 bond, you can file the statement of inability. Again, it has to do with you have to do that within a certain amount of time. And I'm going to go over to another part of the rules here. And this is the other rule. So the 500 series of the Texas Rules of Civil Procedure, they are the rules that govern justice of the peace courts. And if you look at 502.3, you'll see that there's a section on the inability to afford fees. Okay. So this also gives the person filing the case the right to contest the fees. Now, 502.3 talks in the beginning. If you go over to 507, and let me just pull this up real quick for you. I'm sorry, it's 506. If you go to rule 506.1, you'll look at that D here and you'll see the statement of inability to afford payment of court costs, and that is on the appeal. Generally, you have the right to file that statement in order to avoid the appeal bond, but then the other side has the right to contest that, and then the court has to have a hearing. If the JP denies, or if the JP sustains the contest, you can appeal that decision to the county court as part of the appeal of the case from JP to the county court. Again, all that has to be done within a certain amount of time. So it's important that you know that Texas does allow you the opportunity to file this statement. However, it allows the opportunity for other people to contest it. And you have to have a certain amount of time in order to deal with all this. The important rules to remember, again, for regular cases, non-JP cases, are going to be Rule 145. And then for JP cases, you're looking at Rule 502.3. And then you're also looking at 506.1. I hope this has been helpful. Just know that generally there is a time limit by which someone can contest it. And then there's a time limit by which you need to act upon a denial or a sustaining of the contest. One last thing I should tell you about the contest. Whenever you have a contest, it is up to the party who's contesting the statement. They have the burden. In other words, if someone contests it, they can't just contest it and say, well, you got to prove your indigency. No, they have to prove that somehow you have money or assets that allow you to afford those payment of the court costs. And the final thing I'll say this is I do a lot of pro bono work through the Houston Volunteer Lawyers Association, and that is a legal aid organization that's sponsored by the state of Texas. And there are many other legal aid organizations that are approved by the state of Texas. The rules say that if a lawyer files some sort of statement with the court that says he is providing pro bono service to you through a legal aid organization, whether that attorney is on staff or whether that attorney is like me and just does a lot of pro bono work through the volunteer organization, then that, along with the statement, allows the statement not to be challenged. Okay, so if you file the statement on your own, but you don't go through legal aid organization, it can be challenged. But if you go through legal aid organization and the attorney who's representing you, in addition to you filing the statement, also files his or her own statement notifying the court that he or she is representing you pro bono through this legal aid organization, then that basically is proof, and the court's not going to consider any contest. In fact, there can't be any contest at that point. So what I do is, since all my pro bono work is through the Houston Volunteer Lawyers Association organization, I end up filing that legal aid statement in every single pro bono case that I have. And that sort of obviates the need for someone to contest my client's statement of inability to afford payment. Now, for some reason, the client wins a lot of money or comes into some money during the course of the case, that may alter things, but then that also alters things with the legal aid organization as well. I hope this has been helpful. Know that the contest can be done. There are ways to defeat it. There are ways to appeal it. And there are ways where it can't be contested at all. This has been another edition of Legal Grounds Live. Benjamin Sanchez. Have a great day. Bye-bye.